In a landmark decision, the Supreme Court has imposed a stay on new lawsuits and surveys concerning religious sites following challenges to the Places of Worship Act 1991. Now, this act aimed at preserving communal harmony by freezing the religious character of places of worship as of August 15, 1947, faces scrutiny over its constitutionality. The court's interim order seeks to prevent potential conflicts until a final verdict is reached. Joining us now, Professor Mridula Mukherjee, Sanjay Chadha, Senior Advocate at the Supreme Court. I'm also joined by Alok Srivastav, also an advocate in the Supreme Court, and Ashutosh Srivastav, also an advocate of the Supreme Court. So we've got a fairly high-powered panel. I'd like to thank you all very much for being with us. Let me just go across to you, Professor Mukherjee. Some would argue that the act infringes on the fundamental rights of Hindus, Jains, Buddhists, and Sikhs to, for example, reclaim their places of worship. Those who say this argue that by setting an arbitrary cutoff date, 1947, the act prevents these communities from seeking judicial remedies for historical injustices. How would you respond to that?
Well, my answer to that is very simple. 15th August 1947, for one, is not an arbitrary date. You know, that is when we actually got our independence, regardless of what some people may be saying nowadays that we got it in 2014. But, the whole world knows that 15th August 47 is when the modern Indian nation state is born. And that's why it's a cutoff. If we recall what happened at the time of the whole controversy, when it was at its peak, when this act was passed, the Ram Janmabhoomi Babri Masjid controversy, this act, I think, was passed in September of 1991. Yes. The whole idea was that remove the Babri Masjid, Ram Janmabhoomi controversy, because it's already a matter of dispute. It was a legal issue from before independence. But all other such contentious issues or potentially contentious issues should no longer be allowed to come to the surface, and that we have to stop somewhere. As a historian, I have to say that history does not mean that you can keep going back and raking up felt, imagined, real, unreal grievances, wrongs, and spend the next 1,000 years trying to rectify the last 5,000 years of our history. Much happens in history. It happens in the history of every nation. And the period before the modern period, when people are, independence and nations have come into being, is one of conquest empires the world over. In Europe, there's the Habsburg Empire, there was the Ottoman Empire. Now imagine if everybody tries to set right those wrongs. What the Ottomans did to the Slavs, what the Slavs did to somebody else, what the Ottomans the Arabs did in Spain. We will not be able to go forward at all. Right. If, for example, the Indians, the real original Indians in the US started asking for compensation and revenge in the US, where would the US be going?
That it's not
so there is a logic in this.
Yes.
I'll take half a minute to finish, which is that this thing was discussed threadbare in 1991. And it was a matter of trust between all the debates that took place that, yes, we will keep this issue open for legal redress, the Ram Janmabhoomi Babri Masjid issue, but all others, we have to agree as a nation that we are not going to go down that path. And therefore, I think it's also a question of a solemn trust which the nation was given in 1991, not any one party.
Got it.
So therefore, I think questioning this act...
So, ma'am, I got to keep the strike rotating. I will come back to you.
Yeah.
Ashutosh Srivastav, people like Professor Mukherjee and others, who believe that the act must remain, argue that by maintaining the status quo of religious sites as of the 15th of August, 1947, the act, in fact, helps in preserving our communal harmony. It prevents the use of history as a tool for religious conflicts, or political conflicts. Basically, at one level, there is a call for peace and for different communities living together. Isn't that something that we should all accept?
See, if we talk about the same act, the Places of Worship Act 1991, see, there have been certain, exceptions which were mentioned in the same act. For instance, this Ayodhya issue was also an exception. Apart from that, if we see Section 4 of the same act, it says that if certain places are considered to be ancient monuments, and if it comes under the ancient monuments and archaeological, Act of 1958, then in those cases, it can be kept as an exception. And the basic provision of the Places of Worship Act will not apply. Now, many petitions were filed in different courts with that respect. And accordingly, the surveys were allowed by the courts, by the ASI, to do the survey and find out if these places come under the Ancient Monument Act or not. So that was the basic laws or maybe the orders being passed by such courts. But today, if we see the further development which had taken place in 2021, when one Mr. Ashwini Upadhyay filed a petition before the Supreme Court challenging the validity of this particular act by stating that it prohibits or maybe it protects wrongly that some of the invaders who came to our country and they devastated many of the such places of worship places like temples, etc. So it actually protects such kind of invaders. So accordingly, the petition was filed, and to challenge that petition, there were many impediments which were
clarification.
filed.
Isn't it also
Yes.
true that Hindu rulers destroyed Hindu monuments in the past? It's not just Muslims who targeted Hindu monuments, or people of one faith targeting monuments and places of worship of another.
So it is.
Process of
history, it is.
People
the same
of
law.
the same faith destroyed each other's monuments as well. So the question is, how long do we keep physically digging up?
See, the same law applies to the other religion or the other places of worship also. Because see, I'm talking about the law part. The law, if there has been such monument which can be said to be ancient monument, whether it is any sort of, it could have any character of not a particular religion. It could be of any religious place. So this act has given such kind of powers to the court earlier. But when, as I said, in 2021, when the validity of this act itself was challenged before the court, Supreme Court. So now today the Supreme Court said, okay, let us first decide this, whether this Places of Worship Act should continue or not. Suppose if it doesn't continue, then the matter is finished. Then,
right.
that will be a different case.
I get your point. Let me go across to Sanjay Chadha. Mr. Chadha, there's a contention that by preventing courts from adjudicating on the religious character of places of worship based on claims which go before 1947, the Act limits the judiciary's role and therefore violates constitutional principles of justice and equality. How would you look at that?
Well, first of all, for looking into it as to what an act provides, I feel one has to go into the objective of passing that act. As the first speaker has said, that the objective at that point of time, 1991, the situation was such that lot of differences were going on, situations were not under control, and to see that things become normal, the fabric which is going, Indian fabric remains strong, people, the secularism and all those things are there at par, people are at par, the constitutional rights which are given to everybody, whether minorities or majority community, so those right prevails. To look into it, our parliament has passed this law. So what was the objective? The objective was to have a peaceful solution so that no such things crop up tomorrow. We have heard so many people saying that there are many other sites which will also come. There are various developments which are taking place. There was a 2022 judgment also which has authorized or which has given the permission for the survey. Now, today the situation is, which started in 2021, wherein one petitioner and several other petitions have been filed, where the validity, the legal validity of 1991 law is to be decided. And that case is pending before the court today, if I may say so.
Yes.
And the moot question today is whether, if that act is valid or it is ultra vires to the constitution or the spirit of the constitution. That is what's first thing will be decided.
All right.
And thereafter only.
I appreciate what you're doing, laying out the broader judicial parameters, which will be examined by the court. Let's see what happens. But Alok Srivastav, supporters contend that the law embodies the secular principle of our constitution. Why? Because it ensures that historical wrongs, right, do not dictate modern religious practices or ownership. Again, how would you respond to that?
The same secularism also allows the people to practice their religion whose places of worships have been invaded, destroyed and converted into places of prayers. One or two things I would like to tell you. The section 4 of this Act 1991 is very important. It simply says that the places of worship, their religious character shall continue to remain the same as it was existing on 15th of August 1947. Even without abolishing this act, if you have to ascertain the religious character of a place of worship, the only way is to conduct a survey. You'll have to examine what was the character of that particular place of worship, and then you'll abide by the act and you'll continue to preserve the same. So right now, one or two suits in which survey of certain places of worships have been ordered, those survey orders were not violative of this particular section 4. Rather, those were in compliance of section 4. That is first thing which I would like to explain. And that character has to be ascertained. Today's order, with utmost respect to the Honorable Supreme Court, today's order by which Honorable Supreme Court has even barred survey of the religious places of worships, that was something which was in my very humble view, which may not be warranted right now, because even the plaintiff of or parties of the suits were not heard. The provisions of CPC were not complied with. Nevertheless, one or two points I would like to explain to you, because you have very rightly pointed out and tried to elaborate whether secularism comes into the way or not. This particular act was not perceived by our constitution makers, by our framers of the constitutions at the time of incorporation of our constitution. This was incorporated later on in the year 1991 for various reasons, including political reasons. If you see section 3 of this particular act, it says places of worship cannot be converted. Even objective, which my learned friend was talking about, object of this act is also to prohibit conversion of the places of worships. Please remember, there is no prohibition on conversion of places of prayers. So that is one technical point which is important. Second is, our plea is that this particular act itself is violative of Constitution of India, because as you very rightly pointed out in the beginning of this program, of this particular discussion, that how can you curtail the right of religious practices of people? And as I'm telling you, not only the constitutional fundamental rights, but also this particular act is violative of Article 13(2).
No,
and the way it was enacted was absolutely erroneous.
I just for a clarification, you said that.
Pardon?
I just trying to understand what you said when you said that there is a distinction between a place where one prays and a place of worship. There are those who would say that it's one and the same, right? Particularly
yes.
if there are
Sanatan Hindu
which
religion,
are thought to be destroyed or removed. It's one and the same.
So that is what I'm telling you. Two, three things are important. Section 3, see, this act, as you are aware, is a very short act. It has only 7 sections. And section 3, 4 are the important sections. 5 prohibits or gives exemption about Ram Janmabhoomi. 3, 4 are the important sections. Section 3 simply says that places of worship, no one shall convert the places of worship. Now in Sanatan Hindu religion, the temples of Hindu religion are places of worship. Whereas in other religions, the places which are now in the present form, which are converted and formed in the present form, are places of prayers. So there is a difference of worship and prayer, and this particular argument has been taken by the petitioners in this case, and it will be dealt upon by the Honorable Supreme Court. But prima facie, all these suits which are being talked about, be it Gyan Vapi suit, or be it Sambhal suit or Mathura suit, all these suits are talking about places of prayers, not places of worships, as existed on the date of 15th of August. So there is a fundamental fine difference between these two categories. And my simple question is this.
Yes.
How will you ascertain, and I am posing this question to you lastly, how will you ascertain religious character of a place of worship as existing on the date of 15th of August? You will have to adopt scientific measures, and nowadays you don't need to even break those structures. You can conduct scientific surveys, you can conduct GPS without affecting or damaging those religious structures. You'll have to ultimately ascertain the character. You don't have to only see the outlook of a structure, you have to see the religious character.
Therefore, it changes hands, it gets destroyed, it passes from one faith or one community to another. Is that what you're suggesting? I understand the technical arguments and you make them very well. But the point is,
yes,
should there be a change in character at all? Right? Because does it suit all of us on this panel?
So that is what is contemplated in the Act itself.
No, I understand what the Act says. I understand the technical problems. But I think the law, is based, obviously, it's premised on logic. It's premised on peace. It's premised on the basis of communal harmony.
I'll just tell you one example. I think I'll clarify myself. If we talk about...
Professor Mukherjee, I'll come to you next.
This is what I am saying is rather in consonance. What I am saying is rather in consonance with the concepts of secularism, where everyone is given religious freedom. I'll tell you something very pertinent. In Waqf Act, there is a provision wherein section 104 of Waqf Act, wherein the Waqf board can claim any property to be Waqf property, right? So for a particular religion, this freedom has been granted to claim that this particular property belongs to my religion, even though presently this is in the form of or it is entrusted to some other religion, but because, and you might be aware, in many instances even Hindu temples have been claimed by Waqf tribunal, Waqf board, right? So when you are giving one kind of religious freedom to one,
but let's go
so once
Professor Mukherjee, just so that for the purpose of a television debate, while you make your point, Professor Mukherjee, the one key point that you just heard is that there is a distinction between a place of worship and a place where people offer prayer. And therefore, in light of the suits which have been raised, one needs to keep that in mind. Would you like to address that before making your point?
Well, I must say that I'm enlightened. Till now I didn't know this distinction. It obviously takes a very fine legal mind, well-trained in the law, to make this very fine distinction, which, commoners like us, scholars, commoners, we don't know the difference between prayer and worship. And I don't think that the eminent people who wrote this law or the bench in 2009, which gave the judgment on the Babri Masjid, Janmabhoomi, where it actually gave the land on which the masjid stood to the Hindu side, why they bothered to have 5 full pages in that judgment while giving that land to the Hindus, reasserting the Places of Worship Act and saying that this is the condition in a sense. It was almost conditional that we are giving this, but it means that we have to stick to this act. Now, all those judges, all those eminent people, those who wrote the act, none of them ever knew the difference between prayer and worship and all that. Well, we had to wait for Mr. Srivastava to tell us, so I'm enlightened. That's all I can say. But I would certainly like to say that, there is a strong weight of including. I would like to know what he thinks about why in 2019, including Justice Chandrachud, was in that bench. Why did they emphasize that Worship Act so much? I would like to know. If it is so thin, stands on such thin ground, then that whole judgment falls. Are we going to question that whole judgment? Then let's go in and question everything. Let's look below the temple now again. Where are we going to stop? Somewhere we have to stop doing this nitpicking, worship, prayer, this, that, anything to advance our arguments. I'm sorry.
All right, let's leave it over there. There is a pause at the moment.
May I respond?
What the Supreme Court has said. No, we'll leave it over here. The time for this hearing is over, ladies and gentlemen.